Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 171. And ladies and gentlemen, boys and girls, guess what we're talking about today? Yep. It's the coronavirus furlough scheme, yet another update. In fact, this is quite a serious update because we've had a further set. We've got an update on the guidance note on the coronavirus job retention scheme. We've got an update on the self-employment income support scheme, both of which we've written about previously. But, cue fanfare, we need special effects. We now have a Treasury direction, which provides the legislative framework for the scheme and an immediate headache for some employers. What I'm going to do is start looking at the guidance note and the self-employment income scheme support guidance note because they're being updated. So although they are now less important documents given we've got the Treasury direction itself, the notes are familiar and the changes stand out more clearly. And then I'll go on to look at the Treasury direction and what it does. So let's start with the increasingly familiar guidance note on the coronavirus job retention scheme, and this update is dated 15th April. So it's the third update in as many weeks from the government, but in relation to the changes in this document, the pace in the guidance note has definitely slowed down, but there are a number of important changes. First up, the key date for eligibility to the coronavirus scheme has been changed from 28th February 2020 to 19th March 2020. Thus, employers, in order to be eligible, must have created and started a PAYE scheme on or before 19th March 2020. Similarly, employees must have been on that PAYE payroll by that same date. They also need to be notified to HMRC on an RT1 submission on or before 19th March 2020. I understand that for some employers, if people have joined after the 1st of March, but they do their payroll or income tax returns after 19th March, this means that in theory people might have been in the scheme when the date was the 28th of February, but out of the scheme with a revised date. We'll see. Hopefully that'll catch a tiny minority of people. The government had previously provided confirmation in the form of an email that a transfer under the Transfer of Undertakings regulations after 28th February 2020 would not render these employees ineligible to be furloughed. The fear, if you remember, was that employees might be deemed to have started a new employment after the eligibility date. And this eligibility date too has been changed to 19th March 2020. There's some debate online that I've seen about whether that change might leave some employees out in the cold. But again, you would hope there's been a very small number of 2P transfers in that 2.5 week window. And so I wasn't proposing to dive into that particular debate here. It's probably just enough to be aware that there is a debate out there if you have one of those 2P transfers. Those who were employed as at 28th February 2020 and on the employer's payroll, but who then ceased working for the employer after that, but before 19th March 2020, can be re-employed by the employer and then be furloughed. The employer could indeed re-employ them even after the 19th of March and still put them straight onto the furlough scheme. Employees on unpaid leave only qualify for the furlough scheme if they started unpaid leave after 28th February 2020. It's then permissible to switch them onto the furlough arrangement at that point. However, if the employee was on unpaid leave prior to 28th February 2020, they can't be furloughed until the date on which the employee was expected to return from annual leave. Since the eligibility date for employees has changed, this has an impact on the relevant pay period used to calculate the relevant salary being recouped under the furlough grant scheme. You remember the grant applies to the figure of 80% of the employee's salary, which is now to be calculated on the salary in the last pay period prior to 19th March 2020. That, of course, will be different to the guidance note, which bases the salary on the employee's salary as at a particular date, 28th February 2020. Guidance note accepts that the employer is still entitled to rely on the salary as at 28th February 2020, the old calculation method, if it had already calculated the claim it was going to be making for the grant based on the previous guidance. It seems to be clear, however, that employers will be expected to recalculate the grant being claimed and base it on the salary in the last pay period prior to March 19th, 2020, 19th March, 2020, for any subsequent periods of furlough after that. Further guidance has also been provided on the information to be given by employers if they wish to make a claim for the grant through the portal. If employers are furloughing fewer than 100 staff, they're going to have to enter details of each individual being claimed directly onto the system, giving details, name, national insurance number, claim period, etc. If there are more than 100 staff being furloughed by a single employer, then that's to be put onto a file with the information rather than input directly onto the system. We'll see how that works. Guidance notes request employers to keep employees fully up to date on the claims being made on their behalf. HMRC said it is not going to be provided employees with details of claims made on their behalf. This is presumably mostly of importance where employers have furloughed people on the basis that they accepted they'd only get paid when the furlough grant monies came through from the government. Otherwise, the employer remains on the hook to make the salary payments to people on furlough, irrespective of whether it is in funds for the particular period in question, or indeed whether its claim for funds is ever successful. Let's turn to look at the Self-Employment Income Support Scheme guidance note. And I mention this, although it is designed for individuals on their own account, I thought it would be helpful for people to have an update on this as well. They're not employers, they're not employees, but it's obviously helpful to see the framework in the round of support, and indeed employers may be making use of people as flexible labour who would fall within this scheme and who would presumably would welcome the opportunity to be notified of what's out there for them. As I say, the original guidance note came out a couple of weeks ago, but this guidance note for the SIS scheme has also been updated too. There's more detail provided for individuals who are looking to make a claim. In brief, the SIS guidance note confirms that HMRC expects payments under the scheme to be made by early June 2020. As before, it's important to remember it's not employers filling in applications for grants under this scheme, but instead individuals who, in the view of HMRC, appear to qualify will be contacted directly by HMRC as the first step in the process of them then applying for that grant. And the guidance note confirms that contact is intended to be done by mid-May 2020. Note confirms that the SIS grant does not need to be repaid at a later date, assuming it was validly applied for, and does not preclude an individual from taking on work or other employment during the period of the receipt of the grant. However, it will be necessary to confirm to HMRC that the business has been adversely affected by the coronavirus, and this isn't defined, and there may, of course, be some situations where an individual may not be able to show a decline in profits, but is able to argue, truthfully, profits would have been higher but for the coronavirus epidemic. Guidance is provided in the note about making claims for the SIS grant. It reiterates that individuals who have not submitted a self-assessment tax return for 2018-19 must have submitted their 2018-19 tax return by 23rd April 2020, or they will simply be completely ineligible for coverage. There's no mention of any leeway in the guidance note, so this has been presented as a hard stop date. That date again, 23rd April 2020, to get 2018-19 self-assessment tax returns in. If you get the grant is going to be a sum equivalent to 80% of a claimant's average trading profit, up to a maximum of £2,500 per month. Okay, Treasury Direction, which is dated 15th April 2020. This is now the single most important document relating to the Coronavirus Job Retention Scheme. It's essentially the legal framework which will govern the operation of the grants under the scheme. The importance of the guidance note is therefore significantly diminished because it's no longer our primary source of guidance. And in any event, and if I assume in the event of any inconsistencies, you'd obviously expect the Treasury Direction to prevail if the two can't be read consistently. For the most part, the Treasury Direction follows closely in the footsteps of the guidance note, which is obviously a good thing. Focusing on the points, however, in the Treasury Direction which either supplement or contradict the guidance note, these are. So, first, Treasury direction gives HMRC the power to decide what information is going to be necessary to establish entitlement to payment under the scheme. That's obviously not the same thing as the actual entitlement itself, but it's the evidence that someone is entitled. But it does mean that employers are going to need to be alert for record keeping or evidential requirements may be developed by HMRC during the continuation of the scheme or indeed after it's over. There's also general power to reject a claim if the claim being put forward on behalf of the employee is abusive or otherwise contrary to the exceptional purpose of the CJRS, unquote. This is clearly intended as a fail-safe if individuals find creative ways to game the furlough system. The Treasury direction identifies an employee as capable of being a furloughed employee if they meet 3 conditions. First, the individual has got to have been instructed by the employer to cease all work in relation to employment. Secondly, the period for which the employee has or will have ceased such work is 21 calendar days or more. And thirdly, the furlough instruction is, quote, given by reason of circumstances arising as a result of coronavirus or coronavirus disease, unquote. Whilst it is clear, therefore, that it's not necessary for individuals to be facing redundancy in order for the employer to be able to furlough employees, there's going to need to be some link back to the coronavirus in terms of the impact on the business itself. The test is, as we said in a previous update in relation to the equivalent comments in the guidance note, it's a very broad one. Indeed, although it would probably be an abusive claim for a grant and so be denied it on that basis, it's not even necessary for the circumstances leading to furlough to be caused by the adverse impact of the coronavirus. The furlough is to have been by reason of circumstances arising as a result of coronavirus, unquote. It does mean that some of the public debate about whether or not it is ethical for well-resourced employers to make use of the furlough scheme is going to continue. Next point. The scope of the employer's activities on furlough has been tightened. The guidance note said that the individual should not be providing services or generating revenue. This is now altered, so the employee must not be working for a person who is connected with the employer, nor must an employee otherwise work indirectly for the employer. This seems to us to go rather further than the restrictions envisaged by the guidance note. Accordingly, employers will need to check carefully whether they've issued to guidance to employees who are being furloughed about what they can do to see whether that advice still remains correct. Similarly, if employees have been given consent to undertake particular activities by the employer on a case-by-case basis, then employers should reconsider this and see if their approach still fits with the Treasury direction. Deciding whether an individual is connected depends on whether you're looking at a connection with a person or a company. If the focus of the inquiry is whether the new work is for a connected person, then the test is laid down in section 993 of the Income Tax Act 2007. That would include working for an employer's spouse, a relative, or a relative of the spouse. If the test is whether a company is connected with the employer, then that will be determined in accordance with section 112 of the Corporation Tax Act 2010 and applies, for example, if the same person controls both companies or 2 or more persons acting together do so. This is clearly a lot more detailed and prescriptive than the guidance note, which precluded employees from working for or on behalf of the organisation or any link to an associated organisation. Where the individual is already eligible for statutory sick pay at a point when they are furloughed, the furlough period does not seem to begin until the sick pay period to which the individual was entitled has expired. To be honest, I find this really difficult to understand, and the drafting seems to be very confused, and I'm not even sure what it's trying to say. But at face value, it seems to contradict paragraph 21 of the guidance note, which expressly recognised that individuals could be furloughed if they are on short-term illness or self-isolation. This is naturally a material point in the current circumstances, especially since individuals who are self-isolating, in line with medical guidelines, are entitled to claim statutory sick pay as a result of the amendments to the legislation passed by the government. It has to be hoped that this will be clarified as a matter of some urgency. Again, we're in the midst of a pandemic. People are going to be ill, and employers need to know whether they are on or off furlough. Training activities which employees can do also has been curtailed or it's been made messier. I'm not sure entirely which, but this is an important point because the ACAS note and the guidance note both placed emphasis on individuals' ability to undertake training whilst on furlough. And the ACAS note encourages employers to make training available to employees on furlough. And It's pretty obvious. If you are worrying about how people on furlough are doing and worrying about those people who have no work, if we're able to provide some training for them, they may welcome that. It enables the employer to keep in touch with people. It enables the process of upskilling to continue whilst the individual's on furlough. Well, paragraph 6.8 of the Treasury Direction states, and I'm going to read it out in full, training activities directly relevant to an employee's employment, agreed between the employer and the employee before being undertaken, unquote, do not count as work. So it's a really odd formulation when you think about it. It makes clear that some training activities are acceptable, i.e. they don't take the individual outside the furlough scheme if they're agreed by the employee concerned. What does this mean for training which is not of direct relevance? If direct training is fine, provided the employee consents, does that mean the employer is able to require an employee to do training which is not directly relevant without taking them outside the furlough scheme? Or does that require consent too? And who's going to decide whether training is directly or indirectly relevant? On the assumption that employers are not going to be spending their time promoting training that is of no relevance to the employees, then how is an employer going to know whether the training is direct or indirectly relevant? We assume the point is that if the training is directly relevant to the business, you might otherwise think it would count as work. And that would then render the individual ineligible for the furlough during that period because it had broken the 3-week continuity period. But boy, they could have drafted it an awful lot better. Equally, it looks as if an employee has a right to refuse such training activities if they are directly relevant to the business, if they're on furlough. Because once again, remember, the activities have to be, quote, agreed between the employer and the employee before being undertaken, unquote. If consent is not obtained, does that mean it takes the employee outside the scope of the furlough scheme? Employers so far have been looking to follow the guidance note or the ACAS guidance. There's no mention of employees having to consent to any training, so employees may be asked for retrospective consent for mandatory training in the hope that that can cloak that mandatory directly relevant training as having been duly agreed. Treasury Direction also provides guidance on what elements of pay can be taken into account when calculating 80% of the employee's reference salary. Anything which is not regular salary or wages is excluded. Now this is defined as salary or wages which arise from a legally enforceable agreement and which are not conditional on any other matter. More importantly, it excludes any performance-related pay, whether that's the personal performance of the employee or the business of the employer, unless this is enshrined in the legally enforceable agreement itself. In essence, and I emphasise I think this, I'm not sure about it, the scheme seems to be drawing a distinction between matters of contractual entitlement and the discretionary matters, but the drafting of this very short section is most unclear. Bonus schemes, which are laid out in the contract of employment, which relate to company performance, would now seem to be in scope for the purpose of calculating the furlough grant, but not if the employer has a right to exercise discretion in relation to a predetermined set of factors, because that would seem to be a payment conditional on something, i.e. the exercise of the employer's discretion, and in order to qualify, the right must be unconditional. Or is that what it means? Where this will leave allowances which may be conditional on the employer allocating particular work, kind of hard to see. Finally, we have a change to one of the key aspects of the scheme, and it's a bit of a bugbear of mine. Whereas the guidance note had suggested that consent from the employee was required if there were to be changes to that employee's contract, we now have a much more direct statement in the Treasury Direction. The scheme applies to individuals who've been instructed to cease work by their employer. Paragraph 6.7 of the note says, quote, an employee has been instructed by the employer to cease all work in relation to their employment only if the employer and employee have agreed in writing, which may be in an electronic form such as an email, that the employee will cease all work in relation to their employment. So the only way you can show that an employee has been instructed not to do any work is if the employer and the employee have agreed in writing that the employee will cease all work. Regrettably, this now seems to be a clear indication that employees have to consent in writing to be furloughed. Whilst there may be clever arguments of what to do if the employer has a layoff provision in the contract already existing, would an employee's agreement to a prior contract of employment amount to agreeing in writing? The risks have gone up significantly for employers who have not or do not get some form of consent back from each individual employee. It's obviously extraordinarily unhelpful to have this dropped into the scheme in mid-April, when, to our knowledge, many employers have already furloughed staff or are carrying out such exercises this week. If employers are furloughing people after today, we think there's little to be gained by ignoring the Treasury direction and relying on clever arguments about what would amount to an employee consenting in writing. So employers will have to get individual consents. We do not think this has to delay the start of the furlough period itself, especially if the workforce is largely working from home already. We think that an employer has several options if it has already furloughed staff and wants to make a claim in respect of that furlough period. First, and obviously, it should seek consent from individual employees. An employer might use a voting button attached to an email to ask the employee to consent and get written consent by that means. Secondly, the employer should use managers to chase up the furloughed staff to give their consents. Obviously, if a large part of the workforce is already furloughed, this is going to place quite a strain on the remaining managers who are working. But there's probably no alternative to this. The employer will also need to be quite clear about what will happen if employees do not consent. In some cases, the employer may be forced to consider recalling them or making redundancies. This will result, of course, that redundancies result in a greater drain on cash in the short term, in many cases, particularly with long-serving staff. We know that in some cases staff are objecting to being furloughed because they see it as giving rise to a risk of redundancy, and it would, of course, be truly ironic if concerns about that led staff into a course of action which brought about the very outcome they are trying to avoid, i.e. making them redundant. What should employers do if staff fail to respond to such chasing or they object? Well, first, is there any option open to argue that the Treasury direction should not be interpreted too strictly? The requirement is that the employer and employee have agreed in writing that the employee will cease all work. Is it just about possible to argue? It is a real stretch. That a written record that the employee has been told to remain at home to which they have verbally consented is evidence in writing the parties have agreed to an outcome? It's a pretty strained meaning. Clause seems to suggest that the employee's consent must be in writing. Does that mean given in writing or evidenced in writing? So that probably leaves arguments about whether the consent relates to being placed on this particular furlough period or general pre-existing authority under the contract. Would that suffice? Would agreement to proposals from a staff representative committee or a recognised union accepting the employer's furlough proposals amount to agreement in writing by the employee? Is on behalf of the employee good enough? We don't know. Sadly, the effect of the change in message from employers have to confirm in writing employers have to confirm in writing to their employee that they have been furloughed. That's what the guidance note says. To the employer and the employee have to have agreed in writing that the employee will cease all work. This Treasury direction change is going to create a lot of urgent, unnecessary, but necessary, retrospective administrative work. If an employer can obtain consent this week, then they may still be able to make an application for the furlough grant during the April pay period. Otherwise, the employer will be carrying, if he furloughed in March furlough, April furloughed salary costs themselves, and getting some sort of repayment in May. This may be a long way from ideal. But if you can get consent quickly, and by the time the application for the grant has gone in for staff who've been furloughed, you've got consent from them, would that allow you to say that the Treasury directions test has been met? There's nothing which says expressly employees must have agreed before or at the point at which they were put on furlough. It's possible the scheme will be read that way, but in reality, employers who have furloughed staff already have nothing to lose and everything to gain by trying to get some form of email consent sorted out in the next few days. Overall, there's clearly scope for HMRC to address the uncertainties and concerns created by the Treasury direction. In fairness to them, as we keep hearing, these are unprecedented times. So it's to be hoped. It's not surprising that things may have gone a bit astray. They have done an awful lot to get an awful lot of guidance and direction out very quickly. But ultimately, all this comes down to the fact that the legislative process has been inverted. What we have here, the normal process is the legislation is published and then guidance notes are published on the legislation. Here, the guidance notes were published and then we had the legislation. And so that's what's led to a situation where the greater precision and detail in the Treasury direction, the legislation, comes after employers have taken action based on the guidance note. And it's to be hoped that the Treasury will recognise this and through HMRC will put out a revised Treasury direction addressing some of the anomalies. Until then, what's an employer to do? Well, get consent if it hasn't got consent previously, and be aware that furloughing sick ill staff may be a problem, and that the pay calculations are likely to have a degree of ambiguity about them too. Apart from that, last thing I wanted to say was just a reminder, Employment Lawyers Association podcast. I put out a special announcement, but in case people haven't seen it, I've done a couple of podcasts, Employment Lawyers Association previously, so we thought we'd do another one, which was how the employment tribunals are handling the challenges of the coronavirus pandemic. And I ended up interviewing the President of the Employment Tribunals in England and Wales, Judge Brian Doyle, and President of the Employment Tribunals in Scotland, Judge Shona Simon, about the challenges and the changes that are coming as a result with the tribunal system, and what we, the users, can do to assist the tribunals in these difficult times. Do take a listen. It's over at the Employment Lawyers Association website. It's on the webinars page, and the link, if anyone is looking for it, www.elaweb.org.uk/webinars. Do take a listen. It's really good. And thanks everyone, and of course, stay safe.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.